Okay, there are 4 attendees online right now from the public. Charles Young, Diane Baxter, Kristen Lefebvre, and Lori McCarthy. And for staff or panelists, myself, Gail, Greg, Jamie, Jared, Paul, and Terry.
Welcome, everyone. Welcome to the January 9th, 2024 LSP board meeting. My name is Terry Wood. I am the new executive director of the LSP board. For the last 11 years, I've been senior counsel at the DEP's Office of General Counsel, working on a variety of policy matters in the Bureau of Air and Waste, and also doing some work for the Bureau of Waste Site Cleanup before that. And prior to that, for 13 years, I was the general counsel of the LSP board. So I'm coming back to where I started with the state. So I'm very happy to be here. And it might take a little bit of time to get back up to speed from what I remember in the past, but I'm happy to be here participating today. As always, the board encourages interactive participation. And to that end, I encourage you to turn your camera on, as well as ensure that your cell phones are on silent mode. I will now proceed with a roll call to establish who from the board is participating in today's meeting and to also confirm quorum. Please say here or present when I call your name. David Austin.
Yes.
Gail Batchelder.
Hey.
I think that was a yes, we heard you. Greg McBride.
Present.
Kathleen Campbell.
Present. Hi, everyone.
Kirk Franklin.
Here, welcome home.
Thanks, Kirk. Patrick Heron. James Smith.
Present.
Craig Ellis. Paul McKinley.
Present.
We have a quorum and can proceed with the LSP board meeting. And Chris, you already listed who is participating in today's meeting. Has anyone else joined since you gave the list?
Yes, we have Wendy Rundle and Michelle Zelsch have joined.
Thank you. At this time, I would like to turn over the meeting for the Continuing Education Committee meeting to Chairperson David Austin or Gail Batchelder.
Thank you, and welcome everyone. Happy New Year. I'm beginning the continuing ed meeting at 12:04. And there's some announcements, which Matt is doing.
I think I'm going to
Mary's
try to
gonna
do
do it?
them. Yep. So
Great.
the first one is to introduce our new general counsel, Jared Muccio. Thank you. We're very glad that you're here, and we'd like to give you an opportunity to give some background of what you were doing before you came to the board.
Good afternoon. My name is Jared Muccio. Very excited to join the LSP board as general counsel. I've been a practicing attorney for over 6 years now. In addition, I have extensive experience in the maritime community and currently hold a 100-ton United States Coast Guard captain's license. From a young age, I always had a passion for the outdoors. Growing up here in New England has made me appreciate and respect nature, from the ocean to the mountains, and this position fulfills the dream of mine to represent the Commonwealth of Massachusetts along with the environment. It's great to meet everyone, and I look forward working with all the members on the board. Thank you.
Great. Glad to have you here.
Welcome.
So next we'll have an online portal update from Jonah Cucci, who from EEA to talk about the Acela, she's the Acela program manager. Jonah is going to provide the number of LSPs or the percentage of LSPs that have not yet linked their accounts to ePlace. Stepped up outreach to LSPs is ongoing and will continue. We need all LSPs linked to their accounts this month so that we can notify them of the 2024 annual fee payments and for the January 30th, 2024 renewal group reminders. Jonah will discuss other details in terms of rollout status and any issues that need to be resolved. Is Jonah available and ready to speak?
Actually, she was, didn't get the link from the meeting. I think Chris is trying to send it to her right
Oh,
now.
okay.
So we might have to
Yeah.
delay that.
Yeah, I'm gonna have to. Yeah, I have to add her
So-
to the meeting. So while you guys are doing continuing in, I'll get her. I'll get an invite to her.
All right, that sounds good.
You get that to the agenda, David, go right ahead.
Sure. I don't think there's any changes to the agenda. All the virtual meetings, I assume, are online. The meeting minutes.
Yes,
Are
we are.
virtual. Great. For new business, we have 2 course requests for approval. They're both from the LSPA and, oh no, the first one's Mass DEP. It's the MCP amendments training, 3 different formats: in person, webinar, and on demand, and it's for 4 DEP regulatory credits. I make a motion to approve.
A second.
Any discussion from the public or the board?
And just to get a little more clarified, the 2 on-demand and 2 live webinars, they're both 2 hours each. They can be done separately. So when we talk about the course forms, there'll be 3 different forms, whether you do it live or if you take the first session or the second session.
Correct. And in person will be actual attendance, the webinars will be polling questions, and on demand will be assessment of learning.
Yeah, I have a question, Matt, on that. Is it possible for someone to do, of the 2-hour ones, could somebody do 1 2-hour one in person and one, like one webinar and one on demand for the second hour, the second 2 hours?
Yeah, so just to be clear, the live in-person 4 credits, you have to go to all 4 hours. And then once it gets to the live webinar, you can do session 1 live webinar. And then if you want to do on-demand session 2, you can do that. You just can't do on-demand session 1 live webinar session 1. You can't duplicate that.
Thank you.
So a yes is approving. I'm a yes. Gail,
Yes,
Greg?
Is that Greg? Yes.
Greg, yes. Kathy? Kirk?
Sorry, I'm a yes.
Kathy's a
Kirk,
yes. Kirk's a yes. Jamie?
Yes.
Paul?
Yes.
And did anyone else join us? Craig or Patrick?
This is Craig.
So-
I'm a yes as well.
Okay, thank you. So that's approved. And then the next request is from the LSPA membership meeting for this month, looking for 1 technical credit, webinar format, and then a future on-demand format. Make a motion to approve.
Second.
Any discussion from the board or public? Yes is approving the course. I'm a yes. Gail,
yes,
Greg,
Yes.
Kathy,
Yes.
Kirk,
Yes.
Jamie,
Yes.
Paul,
Yes.
and Craig.
Yes.
So that's approved. And then a part of this meeting is the question on the person who didn't get the credits
Yeah,
for
I can take that if you want.
sure.
Okay.
And I kind of know what was going on myself.
Oh, you want to give
No.
documentation? Okay.
Well, no, I'm pretty sure I know what workshop webinar they were at.
Okay, so you attended?
Yeah.
Okay.
And they had problems.
Okay, yeah, so a question came in from a course provider regarding an attendee who didn't realize they had to respond to the polling question to a live webinar in order to get credit for attendance. So we've spoken to the course provider and others, and This attendee indicated that they had never attended a live webinar before where they had to respond to polling questions. I did look into that, and I can confirm that was the case based on past renewal applications, or the last one anyway, even with COVID and a lot of live webinars. This attendee had previously only taken on-demand or live in-person courses. So the question came up from the course provider whether they could attest to the attendance form if the attendee didn't respond to the polling questions. Some course providers will give a warning for the first time, and then after that, they will not issue attendance forms unless polling questions are responded to. So this is a question for the board to decide or provide guidance to the court provider on what to do. And there was some issues with the webinar. The first 10 minutes or so, there was an audio issue. The attendee indicated they didn't hear anything about the requirement to respond to polling questions. They also, this one attendee did have an issue with connecting to Zoom. That's a few more minutes. And David, you want to respond to or talk about the issues with the audio since you were there?
Yeah, and I'm not talking about if the person should have known about polling questions or not, but if it was a certain workshop that I attended at a conference last fall, it was their first time ever doing something on demand online. And unlike the LSPA and EBC, who do it really well, they obviously have a learning curve ahead of them. And there was no audio for the first 10 minutes. So we heard no instructions, and they had to go to a microphone on a laptop, which wasn't that great. I don't think there was a chat option because we were trying to get them to get the audio back on and communicate with other attendees, and it just never worked. And I was talking to some other people who were online, and we all laughed about how halfway through they just got up and left. There was like no announcement of how long the break was going to be. So all of us sitting there waiting for polling questions didn't want to leave. So it wasn't well done, and I think it ended early, but that's not on me. So if it was the same workshop,
It sounds like it was based on the email and the communication.
there were issues, but that doesn't excuse the person from not doing polling questions if it was in writing and they were popping up. I mean, everyone I know did the polling questions, including myself.
Right, and the course provider indicated everybody else did the polling questions. So they knew enough to do it, or they heard the requirement. So this is where we are.
And it was in writing. I mean, the email clearly said you have to do the polling questions. So the person was warned that there are polling questions.
I just wonder if sometimes polling questions don't pop up. I've heard of that, people having technical issues, and they were not able to communicate with the provider. I wonder if that occurred, but I don't know.
I know, I was thinking of that. The one thing that might have happened is the pop-ups may have been blocked depending on their computer and how it's set up. I have heard of that before happening, that sometimes pop-ups get blocked for something like that. So that is a possibility, but I thought, Matt, was it your suggestion that if the provider is willing to let them just view it again and answer the polling questions, or even just give them the polling questions and let them answer them? Would that be something we could allow?
Now, the polling questions, I realize that, it's a testament to them paying attention to the content, but the course provider could also attest to them being present in some other way. Is that a possibility?
No, because that's the whole point of the polling questions. You can stay on the computer and just walk away from it. That was the reason we had polling questions in the first place, was because that was the mechanism to be used to demonstrate that they were actually face to face with the computer while the course was being given.
Sure. Yeah. I feel like we could just give a warning to this person.
Sent to everybody. The course provider could confirm that the attendee logged in at the beginning and logged out at the end. So on their end, they have confirmation that the attendee was logged in for the course. The question comes up with an attendee participating through the polling questions. And Gail, to your point about answering the polling questions after the fact, the polling questions are not an assessment of learning. They're there just to track attendance. So it's a little bit different than just answering the polling questions.
So what if the provider, didn't you suggest that, Matt, that maybe that's an option, or did they suggest that, the provider, let them
Provider
look at it
suggested
again?
that. So that's something you could deliberate here and talk about.
I mean, I'd be okay with the person doing it again. I think that's fair. If they're not gonna, if the provider isn't gonna charge them, then I see that as a reasonable way for the person to get credit after having paid the money.
What are they doing again? Just
Just to rewatch it.
was it recorded?
Yeah, apparently it was. They said that, I guess if it wasn't Matt that suggested it, was the provider that suggested it was recorded so they could watch it and answer the polling questions.
Okay, yeah, because they were going to maybe do on demand later, yeah.
Yeah, they did get approval for the on-demand offering. I believe they were not going to go forward with that. But the course provider did indicate about responding to polling questions. They must have something they can give to the attendee as a follow-up after the fact.
How long? It was a 4-hour seminar?
Yes.
Yes.
So that would be a certain number of polling questions. You would think that if the person got a couple of them right, even if they were given afterwards, that probably they were paying attention. I mean, if they do it a second time, I'm saying if they actually watch it.
I guess who's going to administer this? Who's going to turn it on for the person and make sure the polling questions are answered and that the person is there? And then how many polling questions do they have to get right?
Well, we don't have any requirements for getting any right technically. That's the problem. I mean, we just don't.
Yeah.
Because that's not the purpose of them. That's one of the issues. But
Situation, we're almost using it as an assessment of learning to see if they're paying attention.
yeah, we could. I mean, that's a way to do it. I think that may be the way to do it, is to say, okay, we'll turn it into an assessment of learning because it's an on-demand thing as opposed to a, attending in person thing. So if it's an on-demand thing, you do an assessment of learning, and if they get whatever percentage, I think we've said there's a percentage like 70% or something, then they could get credit.
They're willing to do that, and if this LSP is interested in doing it again. If not, we'll just discuss it again next month.
Should we vote both ways? If they choose to do it versus if they don't choose to do it, how we would respond?
I guess if they choose not to do it, the credits aren't as valuable to them. I think that the polling questions are important because it does demonstrate participation and viewing it. Again, we're not using it for assessment of learning, but as Gail points out, the computer could have been turned on and it just stayed on and they went out about some other business. Either way, I don't think that we should be making an exception in this case.
Yeah, and just
No, would we accept it? Would we accept it if he did watch it again and answer polling questions and assessment of learning?
I didn't mean to say that would not be acceptable. Of course, it would be. It's a time factor, I guess, for the individual to make a decision.
So maybe this is just a rehash of the discussion, but it sounds like, in looking at the email sort of attachments here, it sounds like there is a recording. They could watch the recording, and during the recording, they could note down what the the polling questions are, provide an answer. It doesn't really matter if it's like right or wrong, but wouldn't that suffice? That way that would document that they've actually looked through the whole video, because they would have to pick up the polling questions, write them down in an email and send it to us as verification. Wouldn't that suffice?
Well, they do have to, if it's an assessment of learning, they have to get a certain percentage correct.
I see what you're saying, Paul, and I agree. I mean, it shows that they were paying attention.
Okay.
Yeah.
It was, I mean, one thing I'll say is it was actually a really good course.
Maybe
Yeah,
it would be good for him to see it again then, because maybe he could benefit
A lot
from.
of good new material.
I mean, because this is an exception, you could require that a certain percentage of the polling questions are answered correctly as part of your approval.
Oh, well, we'd have to look into that because we haven't done that yet.
Do we know how
That
many
would be a
polling,
new thing.
maybe Dave, do you remember how many polling questions there were? It was like a half a dozen, 4-hour course.
It would have to be 1 per hour and 2 in the beginning, right?
Should have been.
5 or 6.
5 or 6.
So why don't we go back to them with that proposal, Matt?
Yep, got it. That's
It
underneath.
sounds like the alternative is we're going to deny the request for credits.
Okay. Thank you.
Did you just make a motion?
Does it require a motion?
And so,
I think we're just looking for, the course provider was looking for guidance from the board. I think we have it, unless somebody disagrees.
I think the motion would be if it came to denying an official request.
Right. Right.
I think that makes sense too.
Thanks, Matt.
So, I'm sorry, so what is the actual motion? Because we have to vote on his request. So what are we,
The course provider didn't, it's not a petition. It was the course provider was looking for guidance on what to do.
oh, the course provider.
We go ahead and have the attendee rewatch the recording, send in the polling question answers back to the course provider, and then the course provider can certify attendance that way. If the attendee does not want to do that, then the attendance form can't be issued, and then the attendee has the option to come before the board with a waiver request that the board approve attendance. So right now, it's more guidance and not a waiver request.
But do we have to vote on what information we're sending to the provider?
I don't think so.
I think it's recorded in the minutes, and I don't think it needs a vote.
Okay.
Great, well, thanks for all that. And
Before we end, Jonah, are you on, Jonah? There's a delay. Hey, Chris, you know Jonah dialed in?
I see her.
Oh, there's Jonah. Can you give us a brief report out on Acela, E-Place?
Yes. Hi, good afternoon, everyone. So in regards to the Acela platform, the biggest update is the annual fees for 2024 were assessed at the beginning of the year. So this was the first time that the process has been automated. So it's fully automated through the Acela system. That was successful. Notification went out to 407 LSPs, and so far 118 have already paid, and they all have paid online, and it's just been 1 week. It was last Tuesday, so that's very promising that that's going well. And all the notifications are automated through the system, based on the regulations, when they should go out and according to the dates with the statuses. So we'll watch that throughout the next few months. And then the next one in regards to linking of the LSPs, we're doing well there. The outreach has been working. We are 93% of all LSPs have linked. So it's about 25 LSPs still outstanding. So we're reaching out, and a lot of, during the outreach, a lot of them are retiring or just not planning to renew, not planning to, proceed at this time with anything with LSP. So that's kind of some of the feedback. So this could be some of those folks could be on this pool as well. So we're continuing. We're send emails, we call them, but right now just 25 people are still on that list that haven't renewed. Haven't linked. And next thing we're preparing for is another exam in February, I'm hoping. So that's the next thing we'll prepare with the LSP staff. And then our team is working on reports on continuous process improvements, findings and things that we see with the system, and then data cleanup as we, continue to find, issues with, processes and things like that. So that's high level, pretty much what's going on in regards to the online program for LSP. I'll take any questions.
I would ask a question. How long are we going to pursue the individuals who have not responded? I think at some point it becomes not the organization's problem that they haven't responded.
Yes, so that's a good question. So in regards to LSPs, if they don't link, they're getting notifications, right? So notifications are based on the email address. So we're making sure they're getting all notifications from the system, and the system will act accordingly based on their expiration date and then process-wise. So let's say if they're on that group of annual fees, if they don't pay it by, March 2nd or April 2nd, then the system will take action, suspend them. So the system will act accordingly if they don't respond. So we're just going to follow that process if those folks don't respond. We'll continue to reach out to them continuously, and if they don't respond, the system will, like I said, automatically, act.
I have a question.
People who are in the system and haven't paid, as opposed to people who aren't in the system yet.
Can you repeat that question? I got caught off a little bit.
When you say that will be, kicked off the list, so to speak, that's for people who are in the system right now in Acela and just haven't paid by a certain date, as opposed to the 25 or so who haven't even registered yet.
Well, even if you don't register, right, you have no option to take a look at it and pay. So that's applicable to all scenarios. If you don't pay, if you don't link and pay, all of that, the system will act accordingly. It has set dates and rules that are automated on the process. So it's just going to act accordingly on what the action of the LSP is. But we're documenting all the outreach, and the system documents itself, all the emails that it sends out, and when, and all date stamps. So it's just, at this point, it's up to LSP to do their due diligence on their end.
And we have found some LSPs, they are getting the emails, but they haven't set up the account yet. And they told us that. So we can confirm the emails are going out. Like you said, only 3 were failed emails. So these LSPs, a lot of them are getting emails, and maybe they won't sign up until they have to do something like make a payment or renew an application.
So in other words, the system knows about all the LSPs, even if they haven't linked their accounts. So if they don't pay, they get suspended, even if the LSP was negligent in linking their account. Because the linking only gets them notices so that they're apprised of what's going on.
They have got emails being outside of ePlace itself. They have been emails have been sent out about maybe 8 or 10 since September to remind them to link. So we have that documentation, but you're right. They have until March 1st to pay their annual fee. So if they're not linked in ePlace, they'll have to get linked so they can pay by March 1st.
I see.
But that's my question. If they're not linked, they can't be kicked out. We're back to the old manual system, so to speak.
When you say kicked out, what do you mean by kicked out? Like suspended?
Yeah.
They could be, they should be.
But they're not linked to the system yet. They've only been getting emails saying to sign up for it.
And they neglected to sign up, so.
You get regardless if you're linked or not. They all get, and we've actually called, we also call them as well. We'll call, left messages. We email them separate from the system as well. So the outreach is intensive. Some of them, like I said, you know, we've heard from LSPs who are like, I just don't want to do anything with it right now, and I'm just going to let it suspend or lapse. I'm just going to let it go. Or, you know, we've heard that as well. So the system will just wait there until they let it lapse, until the date to be lapsed will be, you know, it could be 6 months, it could be 5 months, whichever the rules are in the system. So.
I think there's been a significant amount of outreach to the LSP community, both by your organization, Joni, and as well as the LSPA has been reminding people. So if they're not interested in their license, then we shouldn't spend a lot of time on it. And if you've documented multiple times to reaching out to people and they don't respond, I don't think there's anything else we can do. We certainly shouldn't, you know, go visit them, because that's the only thing left to do.
Yeah, that's the only thing left, going to their house.
I mean, we've been down this road. I don't have to remind people we've been down this road before about people not renewing on time for whatever reason. And we just did not agree that you're just not being a professional and being interested in a license if you're not can't care enough to figure out you haven't paid your fees.
And I think this engagement effort has been a great investment for this board, because it's going to offset the chances of getting a ton of waiver requests from folks who were resistant to a new platform, et cetera. So I'm really enthusiastic and appreciative of the work that you.
Thank you.
Thank you, Jonah.
Thanks for the update. Take care. So I'm calling the meeting to an end at 12. Oh, the next meeting will be in February. Location should be determined.
Yeah, and I there's a little note for me. The next meeting will be on February 13th. And during the board meeting, we'll be talking about the virtual platform option that we'll plan to use for that meeting.
Okay, well, thank you. So ending the meeting at 12:33.
And next, we'll turn to the Special and Conduct Committee meeting. At this time, I would like to turn it over to Chairperson Kirk Franklin or Jamie Smith.
Okay. Meeting starting at 12:35. Is there any additions or deletions to the draft? None. Status of complaint review teams.
Okay.
Yes, please.
Okay. Several board members were given the CRT assignments. If you have any corrections or comments, you can let me know. But what we have sent out is what we have for the assignments for each of the complaints that have a CRT assigned.
Yep, Matt, I had a question on that. Why was it not public document when it's always been a public document? You know, that information.
That table has not been sent out to the public, I believe, unless you know otherwise.
No, but that's, I was just trying to figure out, is this the table that's the Excel spreadsheet that says not a public record?
Yeah, because we hadn't sent it out to the public before. So it was Jared's recommendation that since it's not something that was sent to the public before, that it should be listed as that on the table.
Is this just the table that lists the cases and the status?
Yeah.
Yeah, I can say I was surprised that that was not a public record either for my part, because for the entire time that I was with the board in the past, it was a public document. So we can revisit that before next meeting, because I was a little surprised by that myself.
Okay.
Well, I also think there's nothing on it that isn't factual, and therefore it is a public record under the public record. So it's all factual information. There's no deliberations. There's no nothing on that is not factual. And therefore, one, we've done it all along. We did it even under Beverly, not just, you know, when Terry was there. It's always been presented at the board meeting and discussed. We discussed each of the elements.
Yes,
So
I agree.
far as I'm concerned, one, I think legally is a public record because it's factual.
Okay, we'll delete that disclaimer at the top next time. Thank you, Gail.
On the other side, I'd like to say that could this be considered board notes? Because it's pretty much just for us to see where we're at.
Right, but it's still factual information, and therefore we can't restrict public access from the factual stuff unless it's specifically related to some of those, remember those elements that you can withhold public records for, like disciplinary actions that are not completed, personnel matters. Maybe we could set up a thing at some point to go over the public records law again.
Oh, we definitely could do that. I'd be happy to do that in a future meeting if people are interested in that. I agree that document would be a public record. And Kirk, when you mentioned notes, it's true that there's an exemption for personal notes, but that's like the individual person keeps notes that are separate from like a public. This is a public document that's created by the board to be discussed at a board meeting. So I don't think it would fit under that exemption.
Wendy Rundle just commented, the LSPA supports sharing that spreadsheet with the list of cases and CRT composition with the public. Thanks.
So it will be available for next meeting?
Yes, I think we can include it in the packet starting next meeting.
And if I see something that needs to be adjusted, I should just let probably Matt or something that I think is still not quite up to date.
Sure. Yeah, and well, I'll look at that too to see, whatever internal information to make sure that the staff thinks it's as up to date as possible as well.
Okay, are we ready to talk about the updates to the different cases?
Yes.
We'll move forward with that. 05C07, the LSP filed their appeal brief in the appeals court on November 13th, 2023. Yesterday, on the 8th, we did receive an update from the Assistant Attorney General. The appeals court, we had the Assistant Attorney General had submitted a 60-day extension to allow for our brief, for the board brief. So that is due February 13th. The Assistant Attorney General might request an additional 30-day extension to allow for that brief to be reviewed. She indicated that the board can provide comment on the draft brief before the final submittal to the court. And after the board brief is submitted, she said the LSP can file a reply brief, and then after that, oral arguments can be heard. So that's the path forward for that case.
And when did you say we would see something? Did it have a date or sometime that we need to prepare to look at it?
She didn't specifically say what date, but right now, deadline to file the brief is February 13th, so it would be before then. If the court agrees to the 30-day extension to March 13th, it might be after that February 13th date.
But otherwise, we wouldn't realistically have a chance to look at it and discuss it at all before then. And in any case, I guess we'd want, I don't know if that's something we could discuss in a board meeting, or we would need a quasi-judicial or something to discuss. I think we would need quasi-judicial because it's deliberations regarding the right actions on a pending court case.
So our next board meeting is on February 13th, I believe. So are you thinking to have an executive session to discuss that at that board meeting, after the board meeting on the 13th?
Wouldn't it be?
Yeah, I might just need to touch base with her because I'm not sure that she was envisioning the entire board providing comment on it, because it's a legal brief, really about legal issues, not about facts. So I think she might want, maybe myself or the general counsel to look to make sure that everything is stated about the board statute and the board regulations is accurate. I don't think she's probably looking for the entire board to comment on the legal arguments. But I haven't had a chance to talk to her yet, neither Jared or I have, so we will do that shortly to sort of see what she wants. But I think it's more just probably having legal staff look to make sure that the way that the laws of the board are discussed is correct.
Yeah, because I noticed a couple of errors in his brief that were actually factually incorrect statements. And I didn't know if that was the kind of stuff she would care about as well.
Yeah, and I must admit, I know nothing yet. I don't even know what
Yeah,
the issues
okay.
are that are appeal yet. So we will talk to her and see what sort of help she's looking for and go from there.
Okay.
She was pursuing an extension. Yeah, it's kind of like she still was from emails yesterday.
I mean, you're a party to it, Gail. She represents you. Just send her what you have.
Well, no, I didn't. Didn't we get taken off at recently? Didn't they? Weren't they successful in getting us taken off?
The judge said it was wrong to have listed us, but we weren't taken off.
Oh, okay.
I don't think we were taken off. It'd be nice if we were.
Yeah, it would be nice if we were, but I thought maybe that when he said that, that sort of meant that it would revert back to the board as opposed to us individually.
I can find that out too.
Right.
It's a blank slate. I don't know what the claims are or anything.
Yeah, Judge had an opinion on that, but I don't know.
Don't worry, you'll catch up to speed soon enough.
Yeah, take me a little bit.
Okay, for case 08C03, nothing new to report. Likely executive session in February to discuss strategy. Same for 12C01. Nothing new to report other than going through that case and be prepared for executive session in the February meeting. After the February meeting to discuss strategy on that one. 18C01, 18C02, 20C01, 20C02, and 20C04. Be prepared for CRT meetings to be scheduled between now and the next board meeting to get into those cases. So anybody who's a CRT member on those cases will be reaching out to set up CRT meetings between now and the end of the month. Questions? All right, seeing none, hearing none. We have 3 cases to present to the board members for board action. I'm going to pass the microphone over to Gail to discuss a little bit about the procedure and the process in terms of discussing these cases and how to move past forward with complaint review teams and what it's all about. So Gail, the floor is yours.
Okay, and now that Terry's there, there'll be some, I'll have some help on whatever I say wrong. But the reason I thought this was valuable is because when I went through these are sort of complicated cases that aren't the typical DEP submits a complaint, the formerly typical DEP submits a complaint, and it's well laid out and they understand what needs to be presented. And I found going through these that I had different reactions depending on whether I was reading the complaint or whether I was reading the response. And I think it's important for people who have not done this before or have done it only once or twice to know a little bit about how the board has handled these situations in the past when it's essentially a he said, she said kind of feeling when you have read the complaints, and particularly to note that the board has always been or tried to be always cognizant of the fact that when it comes in from the public, you don't always get the right information there. You have to look at it as coming from someone who is not as knowledgeable about the regulations or how the board works or what LSP's roles and responsibilities are. So the information can be jumbled and not make sense. Go ahead. So anyway, so I thought that the important pieces in this one to me were the idea of what the purpose of the screening team is, and it seems to me that an awful lot of the screening team setups in the past were for these types of complaints where you're not sure, it's not absolutely crystal clear what the actual factual situation is. And if this, when you're trying to set that up, the other piece that you're thinking about is if the allegations are true in the complaint, would those allegations rise to the level at which the board would take action? Because sometimes they come in and it may be a minor, something that the public thinks is important, but it's really a minor issue when the board would then say, well, okay, even if this were true, we would not take it. That's when you can dismiss it out of hand. You know, even if it's not crystal clear, it's like, whatever this allegation is, this is not something that we would look into unless there's evidence from something that said that there's a bigger issue in play that the complainant didn't realize because they weren't as knowledgeable. And I sort of feel like these were complicated enough to figure out. And because we did something a little out of order on this one, on the one where we kind of appointed the screening team because we didn't have the redaction software, if everybody remembers that. I think, isn't that 20 CO1, Matt?
21 CO1, correct.
But yeah, so that's the one that Greg and I were put onto a screening team without the board ever having seen the actual complaint and the response because they couldn't be redacted. And it's problematic because it's going to turn out that we can't, because we now know who it is, we can't vote whether or not to accept the complaint. And it made me realize that it's hard to, that the discussion is difficult to do if you've never done it before, to know what the criteria are for the board accepting a complaint or not. But now that Terry's here, I'm more comfortable that even, you know, that people will, you know, she'll help fill everybody in with the critical parts of how you make that call. But that was, I just wanted to have some idea of this back and forth that we do before we decide on the complaint. It's important to keep in mind that if we do not know all of the factual pieces of information, it's generally defaulted to appointing a CRT or a screening team or a CRT. The screening team is different because that means you can dismiss it once you get more information from the screening team and they sort of sort out those facts. It can be dismissed before appointing a CRT, which is a bigger deal than then it's accepted as a complaint. When you dismiss it at the screening team level, it's not a complaint, which is certainly better for the LSP if it deserves to be dismissed.
Okay, Gail, so what you're saying, Gail, is both you and Greg cannot be on the screening team?
No, we'll be the screening team. If you decide to appoint a screening team, we will be it, because otherwise we'd have like nobody left to decide on discipline. So we're just being recused from the discussion that you guys are going to have as to whether to accept it. In other words, it got appointed as a screening team before it should have been, where the board never had a chance to weigh in. And this way, the board has a chance to weigh in correctly by deciding on the face of what you have as a redacted complaint that you will be deciding whether or not to appoint a screening team, dismiss the complaint out of hand, or appoint a CRT right off the face of it. And the assumption is that Greg and I would be either the screening team to look into it in more detail, or the CRT, because I've been through the entire. I have not been through the supporting documents. I've been through the entire complaint and response, which are lengthy, as you know by now. But it would be hard for me knowing who it is, because I couldn't really it'll be in a different position than being able to vote on whether to accept a complaint anonymously.
No, I think you would need to recuse yourself, definitely. And my recollection's a little hazy on the screening team. I want to say that a staff attorney would assist on the screening team
Yes.
as well in the beginning. And there would be an LSP and a non-LSP on the screening team that once it was decided to make them a screening team, they would be told the name of the LSP and the complainant to make sure there were no recusal issues. And yes, then they would go forward and do sort of a more in-depth look at the complaint and any attached documentation. If there are any sort of questions when the board first looked at the complaint and the response they weren't clear about and wanted the screening team to get a little bit more information on, that's my recollection of how it worked in the past.
Yes, but the difference between a screening team and the CRT was that you didn't go into the detail on a screening team that you would on the CRT, because you wouldn't interview the LSP because it wasn't a complaint yet, and you probably wouldn't look at, I don't think you ever would look at other cases like you do in the CRT.
Right, no, I agree. And it sort of, in my recollection, it was sort of like you weren't, the board wasn't sure in looking at it whether they should dismiss it or appoint a CRT. So in those cases where it's not clear, they use this interim step of the screening team. And yes, you wouldn't interview the LSP, you wouldn't do any of the things that you would typically do once a CRT was put together.
What is the recommendation of the screening team?
We don't have one because we've never met. And we can't, technically the board has never actually voted to appoint a screening team. It was something that Beverly came up with because she didn't have the redaction software, and to move the complaint forward, I think we all agreed, it wasn't just her, we agreed that maybe the thing is to appoint a screening team to look through the unredacted documents and come back with a recommendation, but we never got back to it because the screening team never met to discuss it. And we can't, so it isn't a screening team until we actually have a discussion. We've only looked at the documents, but we're recused because we know the name of the person or persons.
So Kirk, I think what we'll do is I'll give a brief presentation about each of the three cases and then let you and the other board members discuss it on what to do next, either to assign a CRT, assign a screening team, or to dismiss the complaint. So that's what the plan is for the next few minutes.
Or appoint a CRT.
Or go directly to a CRT, right? I mean, you don't have to appoint a screening team first.
I said that. Okay.
Are these three new ones or the one that we got this week and the previous one that's all been redacted? Are they included in the three?
In the packet was the most recent one.
Right.
And then the other two were back in August.
Okay.
That were sent out.
So those are the three.
Yeah.
Okay.
So with that, we'll start with 21C01. I'll give a brief background of the complaint and the LSP response. And then hopefully that'll lead to discussion amongst the board members.
And that's the one where.
That's the one that we have to be recused from.
Yeah, so were you the one that, no, okay, so then the two people, that were on that one, I would recommend, turning off their cameras while the board does the deliberation.
So Abigail,
My microphone, but I can't get out of the.
Oh, well, as long as if your microphone is off and you're not participating, I think that's fine.
Okay.
Just make them the CRT.
We don't know yet because you can vote to dismiss.
You might decide.
Okay. I agree.
Okay. So by way of background, two auto parts stores that abut each other. Auto parts store number 2 back in March of 1998, a class A3 REO was submitted with an AUL for a subsurface petroleum release. Fast forward 12 years, 2010, at auto parts store number 1, during a plumbing repair and shallow soil excavation work, contaminated soil was encountered near the property line. In 2015, auto parts store number 1 filed a DPS opinion claiming contaminant migration from auto parts store number 2. In May of 2019, 4 years later, a DPS addendum was filed. In February 2020, based on the DPS opinion and addendum, a notice of responsibility was issued to Auto Parts Store number 2 and required the submittal of phase 1 and tier classification by September 2nd, 2020. On April 9th, 2020, LNAPL was encountered at Auto Parts Store number 1 along the property line. In April 27, 2020, Auto Parts Store number 2 submitted a DPS rebuttal to Mass DEP. On September 2nd, 2020, Auto Parts Store number 2 submitted a phase 1 report and tier classification to Mass DEP. So the complaint was received by us on March 23rd, 2021. The complainant alleges the following, and I summarize the allegations. You have the full list, the full details in the redacted documents. But in summary, the complainant alleges that the submittal of the rebuttal to the DPS included inconsistent misrepresentations and contrary information with respect to groundwater flow direction and with respect to prior use of the site as a dumping area with filled-in wetlands. The complainant alleges the submittal of the rebuttal of the DPS may be a conflict of interest under the LSP Board Regulations 309 4.04. The complainant alleges that the phase 1 report was non-compliant. It was submitted to DEP and contained the following deficiencies: no new soil or groundwater sampling conducted, minimum of 3 wells were not installed, and no technical justification provided for that. They allege the groundwater contour map was not prepared, the source of contamination was not identified, extent of contamination not defined. The complainant alleges that the phase 1 deficiency included concluding that no IRA actions were needed at the site with LNAPL present near the building, and also that the abutter was not notified of the submittal of the phase 1 report. So those were the allegations made about the phase 1 report by the complainant. The complainant alleges that the abutter was never contacted to conduct assessment work on their property. No sampling work was done on the abutting property during the phase 1. Allegation that the LSP did not make a good faith and reasonable effort to identify or obtain the relevant data to discharge professional obligations. Allegation included the LSP did not act with reasonable care and diligence ordinarily exercised by LSPs in good standing. And the complainant alleges that LSP's statements and assumptions are baseless, without merit, unsubstantiated, and without applicable facts and evidence. The LSP response was received by us May 16, 2022, and the LSP response indicated that data and information was reviewed for both properties, so standard of care was met. The LSP indicated MCP reports were submitted timely and in compliance with MCP regulations. The LSP indicated that the site is in compliance. No additional correspondence had been received from Mass DEP and no violations indicated. And the LSP response indicated that there's no basis for the allegations. All work was performed in accordance with LSP standards of care and MCP regulations. And as of December 2023, the current MCP status for the site is Tier 2, with the Phase 2 Comprehensive Site Assessment Report recently submitted on August 31st, 2023, and no notices of non-compliance have been issued. So with that,
The party making the complaint was a public member, DEP?
a public, a citizen.
Okay.
Yeah, not DEP. So I open the floor to discussion.
Screening team.
I agree.
Hey, Matt.
I feel like it warrants the screening team.
Matt, you mentioned a conflict of interest.
That was one of the allegations, yes.
Did they say what the conflict of interest was?
Not really.
I mean, there's a lot of claims there, it's a long list, but the rebuttal is pretty short, and maybe it's all swept away with the screening team, or it's clear to the screening team that there needs to be a CRT.
We have a motion to form a screening team.
So moved.
Second,
All in favor?
was there any more discussion?
Kathy,
Anyone else?
anybody?
I'll just say that this feels like what Gail described as like a he said, she said moment where we don't have all of the information. And I agree with everything everybody has said about the need for a screening team.
I agree.
Now, in terms of the screening team, what additional information should we ask that question? Or the screening team figure that out?
I would just said that unless there's something in particular any of the board members right now would be interested in learning, I think you could leave it to the screening team to figure things out.
In the past, when I was on the screening team, we would access the actual MCP reports and things like that, so we would need RTNs and stuff. But it's not redacted.
No, if you're in the screening team, you get the
Yeah,
unredacted complaint and the response, and
Yeah.
then from that, you go and look at the
Right.
state information. Yes.
Perfect.
Okay, so the screening team would learn about the finer details.
They provide an opinion that it should be dismissed or there should be a CRT.
Gotcha.
Those are the two options from what I recall.
Correct.
And they provide a report if it's as necessary.
Need a roll call?
David,
Yes,
Kathy,
Yes,
Patrick,
Yes,
Jamie,
Yes.
I think that's it because Greg and Gail are not there.
Yep,
Remember
Craig.
yet.
We're recused.
Yep, there it is. Okay. Matt, how do we bring them back?
You can turn your cameras back on and your mics back on, Gail and Greg. Let us know when you're in. Hi, Greg. I
Okay,
see you.
I'm in.
so they're officially the screening team now.
Yes.
They're officially the screening team.
Yes.
Okay.
So I haven't wasted all my time viewing all
On the
that.
screening team, and be ready to report out your opinion next time.
No, it won't be that soon because we still have to,
Yeah,
we
we
have to go through all the information.
At a future meeting.
Yes, at a future meeting. It doesn't happen that quickly, Matt.
But Matt, the other thing is on this
Matt, we
table,
have other CRT meetings to attend in the interim.
Yes.
this is Greg, Matt. Also on this table, there are dates that are passed. And I know that, for example, the November 23 shows up a lot. And I know those were dates that, I don't know what those dates are. They passed, so we should update it to something in the future.
Oh, on the CRT table?
Yeah.
Correct.
Yeah, there's several things that need to be updated. I'll get you my list and everybody should get their own lists of things that they know about from their own CRTs. But I just wanted to, there was something about the screening team. Matt, I do not have the flash drive. I can't find mine either. So I think Greg said he couldn't find his either. That has all of the backup.
After the meeting.
What?
Thank you. Well, we can talk about that after the meeting.
Yeah, I just wanted to make sure you knew that we don't have it to get started. is more than what we've already done.
Matt, do you have anything on 22C01? And
Yes,
23C01?
another presentation and board action needed. Just give me a second. I'm writing some notes here. Okay, so 22C01 is the next on the agenda. No screening team here, so everybody can listen in. And after I give a brief discussion, a brief presentation, you can discuss as a board. Okay, so by way of background, in September 2012, notice of responsibility was issued to a property owner regarding contamination that was reported in an ASTM Phase 2 report. The ASTM Phase 2 report was prepared by the LSP's firm for the city. Contamination consisted of chlorinated VOCs and metals. In June 2014, LSP's firm completed an MCP Phase 1 and Tier 1D classification for the property. It was Tier 1D as the owner filed for bankruptcy. A subsequent Phase 1 report and Tier 2 classification was later submitted for the city in December 2015. The property was unoccupied, and the city was acquiring the property, or had acquired the property in November 2014. In November 2017, an additional Phase 1 report was submitted and reclassified the site for Tier 1 due to an open IRA per a DEP interim deadline. And then the site was later reclassified back to Tier 2 in September 2020 after the IRA was completed. In 2015, redevelopment and renovation activities at the site were initiated. In April 2016, LSP's firm submitted a RAM plan for the city for a proposed SSDS to act as an active or APOM to address chlorinated VOCs detected below the building. It was at this time the LSP became LSP of record. In July 2016, the once vacant property was redeveloped and now open to the public. In August 2016, a potential imminent hazard condition was reported to Mass DEP due to chlorinated VOCs detected in indoor air of the now occupied building. An IRA plan was submitted to DEP in October 2016, and subsequent IRA modifications were submitted in July 2017 and March 2018. A RAM completion report was submitted in November 2016 with the ongoing vapor intrusion work to be performed as an IRA. A passive mitigation and monitoring system was installed in one building in January 2018, and then a separate passive mitigation system was installed in a second building in March 2019. An IRA completion report was submitted in April 2019. In September 2017, LSP's firm submits RAM plan to DEP for the city to deal with construction-related activities and additional site redevelopment. Contaminants included lead and silver in shallow soil and chlorinated VOCs below a former degreaser. In April 2020, LSP's firm submitted an MCP Phase 2 report along with a RAM completion report for the city. DEP performed an audit of the Phase 2 report. In May 2020, identified 6 violations. The NON resulted in the submittal of a revised Phase 2 scope of work, which was submitted in May 2023. More recently, November 30th, 2023, the LSP resigned as LSP of record. So the complaint was submitted to us July 7th, 2022, had 11 counts. I summarized them. Some of the counts I summarized below. First one, the complaint alleges a potential conflict of interest with the LSP working for both the property owner, the city, and the tenant. Complaint alleges inadequate and deficient assessment based on the Mass DEP notices of non-compliance and their directives. Complainant alleges improper selection of remedial approach, not installing a groundwater treatment system, and using a passive venting system instead of an active SSDS. Complainant alleges allowing the redevelopment of the property before the extent of contamination was defined. Complainant alleges failure to test indoor air of new building before occupancy. Complainant alleges failure to follow the LSP board regulations concerning rules of professional conduct by acting in an unethical manner by giving inaccurate and insufficient advice. So those are the allegations in the complaint from private citizen. LSP response October 3rd, 2022, received by us. LSP indicated LSP not responsible for allowing or not allowing the redevelopment of an impacted property. LSP not indicated that they are not authorized to grant or deny occupancy of a building. They note indoor air testing conducted soon after the LSP gained knowledge of occupancy. LSP indicated that the installation of the passive venting system were adequate and met the standards of DEP guidance policies to mitigate vapor intrusion. The LSP indicated that the remedial approach selected by the LSP firm met the standards of the MCP. LSP indicated that DEP's notice of audit findings did not require exploration or investigation of exposure into down gradient residential areas. LSP indicated that there's no conflict of interest since all parties were aware of the LSP representing both the landowner, which is the city, and the tenant. And both parties have similar interests in terms of completing environmental work in accordance with the MCP. LSP indicated no payments were made to the LSP firm or LSP from the city since 2013. LSP indicated they did not provide misleading or inaccurate information, and that LSP held paramount the public health, safety, welfare, and the environment in performing LSP or record duties. So currently, the MCP status for the site is Tier 2, with the revised Phase 2 scope of work submitted back on May 18, 2023, which was later approved by DEP on October 20th, 2023. And the deadline for the revised Phase 2 report is February 28th, 2025. That's the background, and I will open it to the floor for discussion.
Matt, did I hear you say the complaint was a private citizen? Wasn't DEP?
Yes.
Thank you.
I'll say it's a private citizen group, not just one person.
Do we know how many of the complaints that are listed by this party are ones that were identified in the DEP audit? That would be one question. Like,
Can you repeat that?
yeah, how many of the complaints being alleged? Yeah, my apologies. How many of the complaints being put forward by the resident group are actually documented in the DEP audit?
I don't think we have the audit to look at. That's not part of, it isn't part of what we had, is it, Matt?
Yeah, that was one of the attachments that was redacted.
Oh, was it? Okay. Oh, yes, I remember. Never mind. I remember now. I read it a while ago. My recollection is that there are certainly issues at the site, that I thought this was another situation where things aren't clear, and that it might be appropriate for a screening team to try to resolve some of them, because some of them may be resolvable through additional information. I was a little concerned that the LSP did not have any response himself to the complaint. He relied on an attorney to do all of the responding and had nothing personal to add, but that's, not required. So, but it just seemed like there were enough questions that I thought a minimum a screening team should be appointed to try to sort it all out, maybe before we appoint a CRT.
Do we know the relationship of the complainer to the site?
I don't think we
We
I need
can't
to
know.
go back in the past. I don't know how much we talked about the, the identity of the complainant and their relationship to the site. So I wasn't advised answering that right now.
We only have what we have as redacted information, and if we can't tell, I don't think we can. Well,
I think Gail's approach is fine, and people need to keep in mind that the screening team doesn't have to go through everything. If they find enough to say kick it into a CRT, then you're done. So. I mean, there's a lot
either
of-
way, if you find enough to say, listen, it clearly is, this is a he said, she said, but in fact, what he said is factually correct, and because of that, it wouldn't rise to the level at which the board would take action, then it's a dismissal. So the screening team can go either way. So
Correct.
my feeling is that this is too complicated. This is not this is a complicated site with, and I do want to add the one thing that's really important, that the board has always taken issues of critical exposure pathways, particularly vapor intrusion, very seriously. And it would be surprising to dismiss it with just the information we have available.
But does that
I
beg the
think the
question,
question is whether we
why
have
not just have it go to a CRT?
Yeah, whether we directly go to a CRT or a screening team, but I don't think, given the concerns about the critical exposure pathway, that we can dismiss it.
Oh, yeah, I don't think that's on the table.
Yeah. I mean, I could go either way. If somebody, makes a motion for a CRT, I would probably go with that, but I think the screening team is helpful, just to sort out some of these issues, because my understanding is that there were prior LSPs that may have had something to do with some of the actions that are being alleged, not necessarily, not all of the actions being alleged might be related to the CRT, the LSP about whom the complaint is being made.
Yeah, like I mentioned, the LSP became LP of record August 2016. So after some of the initial reports, the ASTM report was done and some of the MCP reports were done.
I second the motion.
To which, do the screening team?
Yes, your idea.
Okay.
Any other discussion or thoughts?
I didn't actually make it as a motion, so I do move that we appoint a minimum a screening team. Let's say that.
David, you second?
Yes, I was the second.
Any other discussion? All right, we'll put it to a vote. I'm a yes. David?
Yes,
Gail?
Yes.
Greg? I think you're on mute, Greg. Jamie?
Yes.
Kathy?
Greg's a yes also.
Okay.
Kathy's a
sorry.
yes.
Patrick?
Yes.
Fred?
Yes.
Okay.
You're missing Paul. That's, I'm a yes too.
Oh, sorry about that.
No worries.
not being on any CRT, I'm willing to volunteer for the screening team.
A non-LSP for the other screening team slot. Any volunteers?
I'm
I'll
happy.
do it. I haven't done one in a while.
I'll put my name in the queue. This is Patrick.
That's fine. You want to take it, Patrick? That's fine.
That might be a good experience for me. Thank you.
Yes, thank you.
This
So
will
we-
definitely be good experience.
That there's no recusal issues, right? Once they know the identity of the complainant.
Yeah, I'll send you both an email with the LSP's name and site name. shortly after the meeting or tomorrow. That's the way we should do it. Normally we take them out of the room, but they're not here.
Yeah, we can discuss how to do it. I mean, I guess, or call them with
Then
maybe,
there's no record.
yeah. I would say
Yeah, I was
call.
gonna say, don't send the email.
Show it
Yeah.
to me and call Patrick.
Yeah, I think that's the way to do it. And then we used to document that in our records too, that there was no refusal issue, is my recollection. Well,
Yeah, we used to pass little papers,
right.
name on little papers.
Yeah, I can take David outside of the room right now. And
Well, is this the end of this committee meeting? Because I was going to suggest a 5-minute break before the board meeting.
there's
Oh,
one
good one more.
short case. to
We
get
could just
through.
do it.
Oh, that short cake, yeah.
We can get through that one quickly. All right, we can do recusal later.
Sure.
Okay, thank you. Kirk, is it okay if I jump to 23 CO1 and a quick presentation and board discussion on that?
Jump to it.
Okay. This is the most recent complaint that we received on July 25th, 2023. The complaint was filed by a gas station owner. The owner alleged that upfront payment of 50% of the contract amount was made on December 21st, 2021, when the contract was executed and prior to the initiation of any site work. Then another payment was made on August 4th, 2022, when the LSP arrived on site to sample wells, which the wells turned out to be dry on that date. The owner alleged that over the next 12 months, the LSP never returned to the site to complete the contracted work or complete the contracted MC report. The owner alleged being scammed. October 4th, 2023, LSP response was received. LSP indicated that an accident and subsequent recovery had restricted work requirements and had affected contracted LSP work. The LSP indicated that subsequent contracted well sampling was recently completed in September 2023. And based on the laboratory data, the contracted report would be completed. At the current time, the MCP status for the site is Tier 1D as of April 2019. The last MCP submittal was an IRA status report from August 2018, and 2 notices of noncompliance have been issued since that time. So that's the background of the case. The potential relevant regulatory provision, CMR 4.03 number 10, which states an LSP shall not allow the use of his or her name by or associate in a business venture with any person or firm which he or she knows or should know is engaging in fraudulent, dishonest business or professional practices relating to the professional responsibilities of an LSP. So it's, I'll let you deliberate. We came in, we thought it was a fee dispute, but might be elevated to something more than that. So with that, I'll open the floor.
Yeah, Matt, did you check into the thing I mentioned about the redaction? Because I think that makes a difference in how I respond.
Oh,
With the
correct.
last part of the LSP's response, it should have been client was apprised of the new results and was pleased, as opposed to the LSP was apprised. The LSP's response says the LSP was apprised.
Yeah, I was wondering about that too.
I think it's supposed to be basically the complainant was advised.
Is it in the LSP response redaction?
Yes, it's in the LSP responses, and it's the last 2 sentences of the second paragraph of his response, the long paragraph of his response. And that's where it says that he informed or somebody informed the whoever, of the results, and the so-and-so was pleased. And it made me think that that things may be back on track.
The last sentence, instead of LSP was happy with that information and look forward to the testing outcome, its complainant was happy.
Right.
You're
That's
right.
what I think it should be. And so it makes a difference in how I respond, which is before we would take it as a complaint or whatever, this one might be worth going back to the complainant and seeing if they still want to pursue the complaint. Because it may be
So,
resolved.
Yeah, you're right. So that last paragraph, I'll read it. The third round of groundwater samples have been collected September 2023 and submitted to the lab. At this time, complainant was notified of the next course of action. Complainant was informed that depending on the analytical results of these samples, the next course of action would be to complete the necessary paperwork to reach site closure. Complainant was happy with that information and looked forward to the testing outcome. This is the LSP response.
So my thought is, at this point, it might be worth having you go back and get in touch with the complainant and see if they still want to pursue the complaint, which is still legitimate, and we would still pursue it because of what the person did, being somewhat negligent in his attention to his client, which is one thing. Also letting things lapse for a period of time that may have resulted in damage to the client in some way. But my feeling is that this is one that maybe the complainant would feel comfortable if things were back on track and would not care to pursue it.
So follow up with the complainant, confirm that the LSP came back to the site, that the complainant's happy with the work and would rather
Or
not
no
see us
longer wishes to
investigating.
pursue the complaint. He doesn't have to be happy with the work. He just has to no longer want to pursue the complaint.
And basically withdraw the complaint, so to speak.
Yeah, kind of. Yeah. I think it's worth checking before we go through something that there are certain allegations that we will not dismiss a complaint just because the complainant wants to, because the allegations are serious enough on their own that, if true, would be an issue that we would want to address. But in this case, it sounds like there may be extenuating circumstances. There may be a bunch of other things that could be at play. Plus, it could be a fee dispute, but it's not a fee dispute because if the person doesn't perform the work, that's a little outside that realm. But my feeling is that it may very well be a situation where the complainant had did what they needed to do to complain, but now that things are back on track, it would be worth finding out if what the LSP alleged, that the complainant was happy, that it would be worth checking. Because again, you don't believe everything you hear.
I did envision that somebody would have that comment, so I did try to call the complainant last week. Couldn't connect, left a voicemail message. I haven't received a phone call back. So that's something that I figured would be necessary. Everybody on board with that?
Like, we could table it till next time, till you find out that information, I think, is what I guess I'm recommending.
Good idea.
Agree.
Do we need to vote?
I don't know if we do to table it.
No, not this table.
Okay.
Table.
Okay, I'll make contact with the complainant and have a update at the next board meeting.
Okay. Any future meetings, February 13th, 2024. This meeting is adjourned, 1:30.
I'll turn to the board meeting.
Yeah, did you want to take a break?
Oh, sure.
Oh, fine.
Okay.
You guys can continue.
Yeah, we can continue. We'll say David, I'll hand it to the room.
Back into the doors while I pass.
Much good stuff.
Thank you.
Otherwise, we're going? Okay. So I call the board meeting to order at 1:30 p.m. And to clarify, I am the executive director, a member of the board staff, so I am not a board member with voting powers. Are there any announcements? Any changes to the agenda, additions, deletions, or changes? So we'll adopt the agenda as written. The virtual meeting minutes from the prior meeting, November 15th, 2023, I understand are available.
Yes, they are. They're on the website.
Okay, old business. I guess there was interpretation question of one of the board's regulations here, 9 CMR 3.092A. I think the recommendation is, because now that we have a general counsel and I am back as the executive director, that we would table that to discuss next time. We can look to see if there's been any historical discussion of the interpretation of this reg before and how that might inform current discussion. The next item is decisions regarding licensing of applicants. Vote on renewal documents. So I think we can put the renewal dockets on the screen. Is that right?
Chris, can you fill up the renewal docket?
They're up, I think, right?
Yeah, I'm on docket 1.
Thank you.
Motion to approve. Docket number 1.
Second.
And do I need to go through the roll call?
Yeah, for docket, roll call.
Okay, docket 1, David Austin. Oh, he's okay. We'll come back to him. Gail Batchelder,
Yes.
Greg McBride,
Yes,
Kathleen Campbell,
Yes,
Kirk Franklin,
Yes.
Patrick Heron,
Yes,
James Smith,
Yes.
Craig Ellis,
Abstain.
yep, and Paul McKinley.
I'm a yes.
Now we can remove to renewal docket 2. Someone
Motion
needs to
to-
make a motion to vote,
Motion to approve.
second,
Second.
and I'll go through the roll call. David's still gone. Gail Batchelder,
Yes.
Greg McBride,
yes,
Kathleen Campbell,
yes,
Kirk Franklin,
Yes.
Patrick Heron,
yes,
James Smith,
Yes.
Craig Ellis,
Yes.
Paul McKinley.
Yes.
Now we'll move on to renewal docket number 3.
I have
Motion
a
approved.
question on this one. Can I ask, it says renewal date is January 30th. They requested a 90-day extension, but the new, this is because it's a renew, it will expire then, but when they make their 90-day extension, it reverts back to January, correct?
That's correct.
Okay, just wanted to check. Okay, I'm good.
So we need a motion to vote on, to approve.
Motion to
Motion to
accept.
approve. Motion to approve.
Second.
Second.
David Austin,
Yes.
Gail Batchelder,
Yes.
Greg McBride,
yes,
Kathleen Campbell,
yes,
Kirk Franklin,
Yes.
Patrick Heron,
yes,
James Smith,
Yes.
Craig Ellis,
Yes.
Paul McKinley.
Yes.
Okay, so the next item is application review panel number 336. Matt's going to give some more information about this one.
Yes. So candidate Brian Klaus, number 2540, ARP panel number 336, met on December 21st, 2023. Craig Ellis, Kirk Franklin, David Austin met to discuss the application. Some of the comments were solid work experience and good background. Typical progression for an LSP, classic 10-year pathway in the LSP world, qualified to sit for the exam. Applicant had good references to match the RPE examples. So the ARP voted to recommend that the full board find the applicant eligible to take the exam. And then the other applicant, or candidate, excuse me, Darren Kirkian, number 9159, was the other candidate for that ARP number 336, met the same day. the ARP voted to recommend that the full board find the applicant eligible to take the exam. They made reference to the 20 years of experience of the candidate, 10 years of RPE, had good decision-making examples and documentation, indicated he was well qualified to take the exam. And one of the members said it was a slam dunk. With that, I make a motion to accept the recommendation of ARP. There was a second.
I'll do the roll call. David Austin,
Yes.
Gail Batchelder,
Yes.
Greg McBride,
Yes,
Kathleen Campbell,
Yes,
Kirk Franklin,
Yes,
Patrick Heron,
Yes.
James Smith,
Yes.
Craig Ellis,
Yes.
Paul McKinley.
I have to recuse on this.
Okay. So the next item is rescinding retirement notice and path forward. Matt's going to discuss this one as well.
Yes. So you've also been given an email from LSP. LSP had a license renewal date last July 2023. They did not renew. Their license lapsed. They indicated that they were going to retire, or they sent us a notice of retirement, not performing LSP responsibilities anymore. Recently in December, they wanted to know if they could come out of retirement, and we really don't have a pathway for that, and it really hasn't been done before based on the discussions with the past board staff. This LSP did pay their 2023 annual fee. That's one of the reasons why somebody might retire, so they won't have to pay the annual fee. This is something that we want to bring to the board for discussion and guidance.
Shouldn't this just be treated the same way any lapsed license would be treated? So it would be a limited application and exam?
Well, I was wondering if, because it's within the 1 year period, if the person could have applied, and if there's a mechanism for them to do that, apply for inactive status and then go off it. Like somehow there's a solution that would not involve the person taking the exam. If that's the only path, then that's the only path. But I was wondering if, because it was within that year, if that is some way that it could be an option to retroactively apply for inactive status back to whatever, July.
If your license is not lapsed, because once you if you have a license in good standing and then you apply for inactive status, you would have to renew. I should say your 3-year window. You have 3 years. So like for this LSP, if they were to go on inactive status on July 29th, they could do that. But once they want to become active again, they would have 1 day to renew. You don't get additional time to renew.
Yeah. No, he went beyond the 90 days.
No, he went beyond the 90 days. Well, first of all, he never applied. Before July 29th, he would have had to apply for the 90-day extension, and he didn't. So he is in the position, I agree, he's in the position of anybody whose license was lapsed, and then apparently, according to the regs, when that happens, and we've got to change that, it says revoked, which is a whole different thing. The license should be lapsed when you just don't choose not to renew. But that's beside the point. He's in that same position as anybody. But I was wondering if there's there's a way that somebody within the first year of letting that happen can get back without I mean, maybe there isn't. I didn't know. I didn't have time to check the regs last night when I was thinking about it.
Yeah, the board staff our thought was the only benefit to going into retirement for that one, within that 1 year is to avoid paying the annual fee. A person could let their license lapse and still have the ability to renew within that 1 year and not pay, and they wouldn't pay the annual fee until they renew. So we were just concerned about maybe setting a precedent for allowing someone to come out of retirement. We want to make sure we weren't missing anything with allowing it.
No, but he wants to come back, so he's asking for the path forward, other than the obvious one, which is you have to do the limited application and take the exam again, right?
No, if you allow this LSP to come out of retirement, they still have 6 months, well, between now and July 30th to renew via a lapsed license. So they wouldn't have to submit a limited application. They could just renew like somebody who had a lapsed license within 1 year.
Yeah, because
That's what I was asking, what the term lapsed means, because I thought we've been using that, didn't pay because he had a renewal. He did not renew his license, which is different than not paying the annual fee.
I just looked at the regs.
It's suspended.
It's lapsed according to the regs.
We're back to what
Okay,
Jamie
so
said.
lapsed, I think
It's
he
treated
has
as a
the
lapse.
year to come back, right?
Yep, they have a year.
Right.
Right, so he
Okay.
can come back, just paying the annual fee and making up his continuing ed stuff that he was supposed to have done, I think.
Right, so that's probably the reason for the question is the LSP wants to know if they do the level of effort to do the additional courses and classwork and then submit a renewal application, would it be accepted? Well, because right now we have him listed as being retired. So it sounds like the board members would agree to allow him to come out of retirement. They'll take the coursework and submit a renewal application.
Yeah, I mean, the regulations allow him to come out of retirement. I mean, it's pretty
Well,
clear.
that's
He's got the
what I
year.
thought. I didn't have time to check, but that's what I thought should happen. So
Because they're agreeing on the
within
same.
the first year, I think you have a year before after your license has lapsed,
you're
right? Isn't that the
right.
regulation, Jamie?
You're right.
So he's within
Matt,
that period. So all he has to do is take his courses, submit his renewal, and pay his annual fee, which you said he already paid, and he's done. Assuming we vote for his renewal.
We'll treat it as a lapse license and we'll let the LSP know that. Thank you.
Yes, Matt, we're not condoning the use of the word retirement though, because this has come up before that people say they're retiring, but they really go into a lapse status.
For a year, right?
They retire to avoid paying any fees. That's
No,
why
but it's
they
the
do
same
it.
thing. We have no
It doesn't
retirement
matter
status, so
what
it
the
is
reason
a
is.
lapsed period. It's a lapsed period.
So in the
We don't
summary,
have, we don't have a retirement status, so they can tell us they're retiring, but that doesn't mean anything to the board. The board has only several categories of no longer being an LSP, and lapsed
Hopefully,
is one of them.
Hopefully the LSP is aware of this, Matt, but I would also just make it clear that he's got until whatever that 1 year date is that he needs to get this done, or it gets more difficult for him.
We do have them let us know if they're going to retire, so we don't remind them or send out notices. They're kind of off of our radar for any future
Right.
correspondence.
But it doesn't change anything about the way they're listed on the website, because it would be, and it should be, lapsed status when they officially never return. No, maybe it's a different status. It's what, maybe we need to just deal with this in the reg.
We actually talked about this in one of our last sessions, talking about the reg edits and that we would develop something called retirement so that they're not considered lapsed, which sounds, negative in the way that the connotation will be negative.
No, it's actually listed as revoked is what happens.
Revoked.
And when it hasn't been revoked, and that's what I'm really upset about. That people have legitimately retired, and it's said revoked.
Yeah.
And so I think we have to do something, but in his case, we have a solution. He has less than 6 months or about 6 months now to solve it.
Okay, thank you for the guidance.
So now we're on number 7, other licensing related matters. And I will let Natasha give us a report.
So for our active and inactive count, we're currently sitting at 420 for active. 2 are currently listed as inactive. In regards to the annual fees report, and LSPs did receive suspension letters. Out of that 10, 3 have paid, 1 has retired, and 6 are outstanding. Those 6 are due to be revoked come end of business day, January 18th. However, just a reminder here, any one of those 6 can come in on the 18th. I'll be here until 6, 7, doesn't matter when. If they can call me, let me know they're coming in, I'll be sure to meet them. They can hand in a check and I will change their status that day.
Okay, so thank you. So that was also the annual fees report under number 8. Number 9, renewal report, January 2024. Matt's gonna handle that.
Yes, thank you. So for January this month, we had a renewal roster of 35 LSPs with expiration date January 30th, 2024. So far, 13 renewal applications have been submitted, and we voted on that moments ago. The remaining applications are due by the end of the month. We'll a fuller report at the next meeting with those that have retired or let their licenses lapse.
So on to number 10, petition for waiver, exam expiration. Matt's going to discuss that as well.
Everyone got an email about an applicant. They had initially been approved to take the exam January 11th, 2022. So they have until January 11th, 2024, 2 days from now, their 2-year window. They initially took the exam on November 15th, 2022, did not pass. Took the exam again, most recently, November 1st, 2023, did not pass. So they have a petition to extend the window and allow them to take the next exam, which we are planning to administer the end of February.
So there was not a June or spring test in 2022, correct? And there wasn't one this year, so there's only been the 2 exams, November of 2022 and 2023, I think.
I know in 2023 there was only one in November.
In 2022, there was only one. I think there was only one, but we should check.
Okay, because sometimes, some years there were 2, but I don't think so in
Yeah.
2022.
I couldn't remember because I had a note on to look at how many opportunities he had to take the exam during his licensing, during his eligibility period. And that did seem to matter to me, that if he only had those 2 chances.
I think we should allow the person to take the 3rd and last exam either in February or November of this year.
Well, if we do that, then what we need to consider is that we'll do it in other circumstances where the person is within a month or 2 of, it loses their eligibility, and then there's another exam within a month or 2 that we would have to give it to them too, basically. I mean, if to just make that it's going to end up being a policy if we do that. That being said, I was leaning that way of letting him take it, but because he had at least a cause shown for why he wasn't able to study. I mean, I think that's another issue for us to discuss. We've said we don't take family illness as a legitimate excuse, but quite frankly, I think maybe we should reconsider that approach, because we say family is important, and if any of us were in that position, and our child or our wife or husband or whatever were sick, I think we would all put them as the priority and not an LSP exam.
Yeah, but that's kind of a moot point. There were only 2 exams available
Right.
during
Well,
the
but
period
that's all.
that they were eligible to take the test, and they failed both. So
I know.
we'll
I
give them
know.
another try. We've done it in the past.
We've done it very rarely because by law, we only have to give it once a year. So that people don't have infinite opportunities to take the exam. But in this case, I sort of feel like I think we need to sort of think about this, what we would require for someone to say, my family had to be put first during this period, as opposed to just I was sick. That's another issue for another day, but we are creating a precedent by letting him stretch it out for that extra month of his eligibility.
We talked about
Not
whether
a
or not,
precedent. We've done it before. We have done it once before. I know that.
Let's hear what other people think.
but I just want to point out too, in March, we did hear a similar petition. And it was reported that there was only 1 exam in 2021, only 1 exam in 2022, only 1 exam in 2023. So this person was granted extra time to take the next exam that was offered, which turned out to be 6 months after their window. But the good cause there was the sparse offerings of the exams.
Yeah, but that's not, we've got to reconsider that, because that's not a legitimate option, because originally the way it was set up, you only had to give the exam once a year. There were plenty of times when the exam was given only once a year.
Back in March.
Right, so we've already done it.
We have. I'm saying we have done it. I just think we need to be conscious of the fact that when the whole thing was set up, it was set up for only 2 exams within your eligibility window. That was the way it was set up.
That's for
We
another
then
day.
went a little crazy and had exams on demand, and that was ridiculous. So that went away. But I'm just saying, the 2 exams is kind of the way it was planned. That being said, I was still leaning towards saying he could take it because it was only a year out, a month out from when he lost his eligibility.
Yeah, I agree that whether we've done it before in the past or not, I believe that extending it for a period of time is acceptable. David, I don't agree that we should let them go through November if there's an exam then. I think just the next available exam.
Greg, I was going to
That's
say
fine.
the exact same thing, that I'm inclined, but like for the next exam coming up imminently in February would seem appropriate. And it sounds like the precedent has already been set. So there you go. 1-2.
We should check this for our good cause waiver kind of thing too.
I make a motion to allow the petitioner to sit for the February 2024 exam.
Second,
I'll do the roll call. David Austin,
Yes.
Gail Batchelder,
Yes.
Greg McBride,
Yes.
Kathleen Campbell,
yes.
Kirk Franklin,
Yes.
Patrick Heron,
Yes.
James Smith,
Yes.
Craig Ellis,
Yes.
Paul McKinley.
Yes.
Okay, the next, item 12, regulations revision update.
That's the exam committee report.
Oh, I'm sorry.
Oh, sorry to
Sorry.
interrupt. I get to hop off now, but it's Craig.
Thanks, Craig.
Take care, Craig.
Bye, everyone.
So the exam committee met today. We had a bunch of great announcements, and we approved 2 courses.
No, you're ahead of us. Exam committee report.
I know. So I'm doing.
You're continuing that.
Oh, this is about
Oh my God.
reviewing the exam. I guess Matt's gonna give us a report.
Failed that exam.
Well, I missed that.
She threw me off.
Yeah. my fault.
But see, you have my report now for 13. We're all done. I will say that Matt's doing a great job with the exam committee.
Okay, exam committee,
Doing a great job.
we met December, we had a meeting, and then more recently last week. We're going through both exams and flagging, identifying questions that might need to be revised based on the new MCP amendments. So those exams will be revised for the fall 2024 offering. And we're also in the process of, we're going to start the process of generating a fourth exam. So that is in the plan for the exam committee. And the next meeting will be in 2 weeks.
Okay, now we're on to regulations revision update number 12. I understand from my notes here that all board members should have received a full red line strikeout of the reg revisions. And they should encompass all the changes that were discussed over the past years. This is saying a request that all board members review over the next few weeks and be ready to provide clarification or corrections during the next committee meeting. I would also like some time to review those too, since I'm new, because I might have some comments on them as well. There are some new items to consider, and there's some finality with the online portal language and requirements, yet to reflect that now payments can come in and things are electronic. We ask at this time if any board member has not received the red line strikeout file, or if any board member has any immediate concerns, to let us know about that file.
I don't know, when did they get sent out? Because I'm not sure I saw them, or maybe just missed them somehow.
It was towards the end of November, right after.
Oh, then, way back.
Thanksgiving.
Okay, I'll check. I don't have them in my files. That's why I need to go back and check for the email.
Okay, so number 13, the continuing education committee report we already had.
Well, no, we have to vote. We have to vote on it.
So you heard what we did, and a motion to, what do you say? You know? To adopt the recommendations of the continuing ed.
Right. And
Second.
did you already move that? And I'll second it.
Thank you.
Okay, I'll do the roll call. David Austin,
Yes?
Gail Batchelder,
Yes.
Greg McBride,
Yes,
Kathleen Campbell,
Yes,
Kirk Franklin,
Yes,
Patrick Heron,
Yes,
James Smith,
Yes.
Craig Ellis. Oh, right, sorry. Paul McKinley.
Yes.
Okay, so now we're on to 14, the professional conduct committee report. Kirk?
I'd like the motion to accept as presented in the professional conduct meeting without having to review the whole thing.
Well, we don't have to because it's a committee of the whole, and therefore we all participated and voted then.
Is that a second?
That's the difference. No, we don't have to vote. It's
Okay.
already done. Any votes in professional conduct count as votes. It's only continuing ed because it was set up as a subcommittee.
Okay.
That sounds familiar, but I must admit I don't remember right now, but that sounds like that makes sense. 15, other business, personnel and budget. So as we discussed today, I am now the new executive director. We have the new general counsel. So the board staff is complete. There are no open positions at this time. The budget prep for FY 2025 will soon get underway. The next item, LSP board member vacancies. Currently, there's still a new vacancy for the chairperson. There should be more information about that coming soon. And there's also the environmental protection slot is open. 2 individuals have expressed interest, both are LSPs. Another individual, a non-LSP, expressed interest and submitted an application yesterday. That application will be reviewed by myself and the chair when the chair gets put in place. And the vacancy notice remains posted on the LSP board website and the LSPA website, and ongoing outreach continues for both slots. Future meeting, the next meeting is on February 13th, 2024. And my understanding is there's been some review and testing of different virtual platforms, GoToWebinar, Teams webinar, and Zoom, and the plan is to switch to the Zoom platform for the February meeting. And now we're at 17, the adjournment. I'm calling this meeting adjourned at 2:01 p.m.
Is the February meeting hybrid with Zoom and in person?
Oh, I'm sorry, yes, listed here that it will be hybrid, so people that want to come into Boston for that, that would be fine, and otherwise people can join on Zoom.
Thank you.
Thanks,
Great meeting.
everyone.
Thank you.
Bye.
Yep.
So long,
Bye,
folks.
Thanks, everyone.
Guess we didn't have to amazing to hear someone say that. Unbelievable.
3 years, right?
Wow.